The Supreme Court just handed down an 8.1 decision that is sending shockwaves through every gun owner in America. And what happened is going to change everything you thought you knew about the Second Amendment. Missouri tried to do something no state has ever dared to do before. They built a wall between their citizens and federal gun control. And the result is that it responded in ways no one saw coming. Whether you're pro-gun, pro-control, or somewhere in between, make sure you hit that subscribe button right now, because this story is bigger than most people realize. And you're going to want to stay updated on what happens next. No one saw the $50,000 coup coming. Missouri didn't just pass a law. They declared war on federal authority in a way that hasn't been attempted since the Civil Rights era. And the numbers behind it are staggering. When the Second Amendment Protection Act went live, it made the system of financial penalties so harsh that local sheriffs in 114 counties faced an impossible choice: follow federal guidelines or face personal bankruptcy. Even a $50,000 fine wasn't a one-time slap on the wrist. Legal experts estimated that an officer cooperating in multiple federal cases could rack up more than $200,000 in fines in a single year. What made it even more explosive was the provision for civil lawsuits. Any Missouri resident could become this kind of bounty hunter, filing a civil lawsuit against law enforcement agencies that dared to work with the ATF or FBI on gun-related matters. Within the first 6 months of SAPA's existence, more than 47 lawsuits were filed against various agencies, creating a legal nightmare that cost taxpayers millions in defense fees alone. The county budget began to hemorrhage money just to prepare for potential lawsuits. Sanctuary City blueprint backfires. Missouri's legal team borrowed its entire strategy from progressive sanctuary cities. And the irony is absolutely mind-blowing. Between 2015 and 2021, more than 560 cities and counties across the United States declared themselves immigration sanctuaries, refusing to cooperate with ICE and federal immigration enforcement. These jurisdictions set a legal precedent known as the anti-commandeering doctrine, which the Supreme Court has actually upheld multiple times. Constitutional experts have observed that cities like San Francisco, New York, and Chicago successfully blocked federal immigration agents from accessing local jails, using local resources or obtaining information from municipal databases. Missouri's attorneys studied every single one of these cases, spent over $340,000 in legal research, and thought they'd found the perfect loophole. They argued that if liberal cities could block ICE, conservative states could block the ATF. The logic seemed bulletproof. Here's the problem. Missouri made one critical mistake that the sanctuary cities carefully avoided, and that single miscalculation destroyed their entire case. What they did differently was so subtle that even legal experts initially missed it. But once the court spotted it, everything fell apart. Justice Thomas stands alone again. When that 8-1 vote came down, it revealed something extraordinary about Justice Clarence Thomas that most Americans don't understand. Thomas has now stood alone in dissent or unusual positions 73 times during his tenure on the Supreme Court, more than any other sitting justice by a factor of 3. His judicial philosophy centers on originalism, so strict that he's willing to overturn precedents that have stood for over a century if he believes they contradict the Constitution's original meaning. In the Missouri case, Thomas didn't even write a full dissent. He simply noted he would have granted the stay, which in Supreme Court language is the equivalent of saying the other 8 justices are missing something fundamental. Legal historians have compared Thomas's lonely positions to Justice John Marshall Harlan's solo dissent in Pye versus Ferguson, the 1896 case that upheld racial segregation. Harlan was right, and history vindicated him 58 years later with Brown Visa Board of Education. Thomas's supporters believe he's playing the long game, planting seeds for future courts to reconsider federal power. His critics argue he's become so ideologically rigid that he's lost touch with practical governance. Thomas's vote wasn't actually about guns at all, and what he was really defending has implications that go far beyond the Second Amendment. The Bruin Revolution changes everything. Just 3 years before Missouri's defeat, the Supreme Court handed down the Bruin decision that completely transformed Second Amendment law. And most people still don't understand how radical that ruling actually was. On June 23, 2022, the court established a new test. Any gun regulation must be consistent with America's historical tradition of firearm regulation. This threw out decades of legal framework and replaced it with a historical analysis that's causing chaos in courtrooms across the country. Within 18 months of brewing, over 450 federal and state gun laws were challenged in court. Judges suddenly had to become historians, examining musket regulations from the 1700s, dueling laws from the 1800s, and frontier gun policies from the Old West. The success rate of these challenges skyrocketed. Before Bruin, gun rights advocates won approximately 23% of Second Amendment. After Bruin, that number jumped to 67%. Lower courts have struck down laws banning guns in parks, churches, and subways. Age restrictions preventing 18-year-olds from buying handguns have fallen. Concealed carry bans in 6 states have been overturned. Gun rights organizations have filed over 89 million in lawsuits using the Bruin standard, and they're winning far more often than losing. So, if Bruin was already winning the war for gun rights, why did Missouri need SAPA at all? The ATF factor nobody mentions. Behind Missouri's extreme reaction was a federal agency that's become the most controversial law enforcement body in America. And the statistics explain why gun owners are genuinely terrified. The Bureau of Alcohol, Tobacco, Firearms, and Explosives conducted 37,172 compliance inspections of gun dealers in 2023 alone, a 340% increase from 2016. These inspections have resulted in the revocation of 122 federal firearms licenses, effectively shutting down gun stores for paperwork violations that owners claim are technical errors. The ATF has also used regulatory power to reclassify items without congressional approval. They declared bump stocks to be machine guns, forcing over 520,000 owners to either destroy their devices or face federal felony charges. They've redefined what constitutes a firearm to include partially completed receivers and frames, creating criminal liability for hobbyists building guns at home. Most controversially, the ATF maintains a database that contains more than 920 million records of firearm transactions, despite legal restrictions against the registry. When gun dealers go out of business, their records go to the ATF's National Tracing Center, where they are scanned and archived. Gun rights advocates call it a backdoor registry. The ATF calls it a crime-solving infrastructure. Missouri lawmakers looked at the numbers and were alarmed. They saw federal agents wielding the power to criminalize gun owners overnight through regulatory changes that completely bypassed the legislative process. But the solution to countering them created an even bigger problem that ultimately gave the federal government more power than it was trying to resist. Explain the trap of the Supremacy Clause. Article 6, Clause 2 of the Constitution is just 68 words long, which destroyed Missouri's entire legal strategy. And to understand why, one needs to look at the most dangerous precedent in American history. The Supremacy Clause establishes that federal law is the supreme law of the land when state laws conflict. But here's what makes Missouri's case so fascinating. They weren't actually trying to overturn federal law. They were using the anti-commandeering doctrine that the Supreme Court has repeatedly upheld. States can't be forced to enforce federal law. The court established this in 1997 in Prince v. United States, when it ruled that the federal government couldn't require state law enforcement agencies to conduct Brady Act background checks. Missouri thought they were on solid ground. The problem was their language. SAPA declared federal laws invalid within Missouri's borders. That one word nullified their law by non-cooperation. Nullification was a doctrine that southern states tried to use before the Civil War, claiming they could invalidate federal laws in their territory. The North won that battle and the legal question was settled. States cannot invalidate federal laws. Missouri lawyers insist the difference is semantic. They argue that refusing to enforce a law and declaring it invalid are effectively the same thing. The courts agreed with the federal government. But here's the scary question. If Missouri had changed just 5 words in its law, they might have won. What does the 8-1 vote really mean? This Supreme Court vote tells a story that goes beyond guns and reveals a fault line in conservative legal philosophy that is about to explode. The 6 conservative justices include Amy Coney Barrett, Brett Kavanaugh, and Neil Gorsuch. All were appointed specifically for their original ideas and skepticism of federal power. Still, they voted against Missouri without hesitation. It wasn't a close call or a landmark decision. What it shows is that even the most conservative Supreme Court in 90 years has strict limits on how far it will allow states to challenge federal authority. It will expand individual gun rights through cases like Brevin. It will limit federal regulatory agencies through cases like West Virginia, through the EPA, but it will not allow states to active